Good afternoon, everybody. For those of you who don't know me, my name is Jim Anaya, and I'm the Dean of the University of Colorado Law School. It's my pleasure to welcome you to this conference on Section 512, Safe Harbor, Challenges and Opportunities in User-Generated Content. This is another one of the great events put together by the law school's Silicon Flatiron Center. Silicon Flatiron is an innovation center at the intersection of law, policy, and technology. In addition to its policy work, the center hosts dozens of conferences, workshops, debates, and fireside chats throughout the year, bringing some of the best and brightest thinkers about the future here to the law school and to the Boulder community. The center aims to elevate the debate surrounding technology policy issues and to lend intellectual honesty to complicated issues like the one you'll be discussing this afternoon here. This event is part of the Content Conferences series, which is now in its fourth year. The series is particularly focused on bringing diverse viewpoints together to identify common problems and solutions. Here at Colorado Law, above all, we aim to educate, inspire, and support our students as the future leaders. Just prior to today's conference, the Silicon Flatiron Student Group organized and hosted a student-led primer on the conference topics and a career panel for those interested in copyright and copyright policy. Students also took the lead in organizing all of the travel and ground transportation logistics, making this a student-led affair from beginning to end. The principal organizer for today's conference is Cristelia Garcia, a law professor here at the law school. Clearly, her background is very well suited to today's discussion. In addition to teaching trademark, property, and copyright-related courses, Professor Garcia serves as director of the Content Initiative at Silicon Flatirons. Her research is focused on law, technology, and economics, with a particular emphasis on efficiency, competition, private ordering, and distributive justice. Prior to joining Colorado Law, Professor Garcia was a visiting associate professor and the Frank H. Marks Fellow at the University of George Washington University. She is also a visiting fellow at the Information Society Project at Yale Law School. As a practicing lawyer, Professor Garcia worked in the music industry in Los Angeles. First at Quinn Emanuel as outside counsel to Napster, then as director of business development in charge of content licensing at MySpace Music, and most recently in digital strategy as director at Universal Music Group. I wish you all a productive conference, and I now give you to Professor Cristelia Garcia.
Thank you, Jim, for the introduction, and welcome to everyone who is able to make it in person with us today, and welcome also to our live stream community. I want to give a special thank you to a few folks before I introduce the topic and what we'll be talking about today. A special thanks to Phil Weiser, our fearless leader and founder of Silicon Flatiron Center, for his, founding of the center and his continued support of this particular conference, all of my colleague co-directors for their support, and Silicon Flatiron's amazing support staff, Anna, Susanna, Sarah, Kelly, and Vanessa, who really are the folks who put this together. But most of all, I'd like to thank our students for all of their work on this, especially Galen, who many of our panelists worked with extensively, and who single-handedly shepherded all of the logistics around a conference like this, which is quite an undertaking. All the folks who've taken copyright with me, and the seminar students who are joining us today, the Silicon Flatiron Student Group for putting on the primer and the career panel prior to this, and of course any and all students who've participated in offering rides to our speakers. I really appreciate that as well. Today we're going to be talking about a pretty niche topic, so I appreciate the interest of those who are outside of the industry who can relate to this and find it interesting. It's an especially timely topic, and so for a nerd like me, this is really exciting. Today we're going to talk about Section 512 of the Digital Millennium Copyright Act, an amendment to the Copyright Act of 1976 that was passed in 1998. To put that date in perspective, right, 1998 is the same year that Google launched, and Napster wouldn't come along for another year, and then followed several years later by Facebook in 2004, YouTube in 2005, Twitter in 2006, and Pinterest in 2010, to name just a few of the platforms that currently operate under this particular section. Our first two presenters today, for those who aren't as familiar with the background and what the issues are around this, are going to break down exactly what Section 512 says and why, so that we can all be on the same page as we begin our discussion forward. Next, we'll start our second panel with some content creators and content owners and supporters and consumer advocates as to how well or not the safe harbor is faring these days. Sort of what does it look like on the ground, what's working, what's not working. Then our third panel will turn to the online service providers and internet service providers themselves to consider the technological limitations of the safe harbor, to consider the logistics of notice and takedown, and the pros and cons of these new private agreements that are beginning to not only supplement, but in some cases even take the place of Section 512. And finally, our last panel will consider the way forward with official policy proposals ranging from amendment of Section 512 to the introduction of best practices to continued voluntary private agreements. Our last group of panelists will address the future of regulation in this area. I think that we are in for a treat. Thank you again for joining us today, and please, if you're able, don't forget to join us for our reception afterwards. It will take place next door. Without further ado, I will turn it over to our first panelist. Thanks.
Trying to get that to.
This is yours.
Yeah. There we go. Thank you. Okay, what would a conference be without a small technical difficulty at the beginning? Okay. So Professor Garcia invited me to get things started this afternoon by talking about the legislative history of the DMCA, which I'm really happy to be here to do. So I'd say the history of the DMCA begins with what John Perry Barlow in 1994 called the problem of digitized property. The enigma, Barlow wrote in Wired magazine, is this: if our property can be infinitely reproduced and distributed all over the planet without cost, without our knowledge, without it even leaving our possession, how can we protect it? How are we going to get paid for the work we do with our minds? And if we can't get paid, what will assure the continued creation and distribution of such work? In 1994, Barlow saw no solution to the problem and declared that we are sailing into the future on a sinking ship. So I invite you today to think of the DMCA as an effort to keep that ship afloat. And though people in the room may disagree, and we may hear about that a little bit later, my own view is that the ship has not yet sunk. So the road to the DMCA safe harbors began not in Congress, but in the courts. And so that's where I'd like to start today. Our early cases testing the application of copyright law to online services reached inconsistent results. The two most famous early cases are probably a case called Playboy versus Frenna from 1993, and one from 1995 called Religious Technology Center versus Netcom. So in Playboy, the court held that the operator of an online BBS was directly liable for infringing the distribution and public display rights in Playboy's copyrighted photos. The photos at issue were uploaded to the BBS by its subscribers, as you might expect, and not by Frenna himself. As its rationale for holding Frenna strictly liable, the court said that he supplied a product containing unauthorized copies. and that it didn't matter whether he knew about them or not. Okay, so in Netcom, a different court presented with essentially the same facts reached the opposite conclusion. It held that the defendant BBS operator and his ISP were not directly liable for infringing the plaintiff's reproduction right. Here, the case was dealing with the copyrighted works of L. Ron Hubbard, the founder of the Church of Scientology. The plaintiff's claims, the court said, should be analyzed under secondary infringement doctrines and not in terms of direct infringement. The court in Netcom actually distinguished Playboy, but not in a way that made any real sense. So the difference in the two holdings is critical because it's the difference between unconditional and conditional liability for infringement for service providers. Right holders obviously preferred the Playboy analysis, and service providers obviously preferred the Netcom court's analysis. So there was really no early consensus in the courts about how all of this online copyright stuff should go. Okay, so meanwhile, in the executive branch, staff at the PTO were formulating the Clinton administration's plan for action dealing with the problem of digitized property. In 1995, the Department of Commerce published a white paper on intellectual property and the National Information Information Superhighway. The NII white paper was really everything I think the copyright industries could have wanted it to be. It proposed that there should be no limits on liability for online intermediaries because liability was simply the cost of doing business online. The paper argued that intermediaries are the lowest cost avoiders when it comes to policing copyrights and that all their liability problems could be solved with indemnification and insurance. Between these two relatively innocent parties, the report's authors wrote, the best policy is to hold the service provider liable. That policy makes excellent sense if you're a copyright holder, and I think probably terrible sense if you're a service provider. As an appendix to the white paper, the NII included draft legislation, a bill called the NII Copyright Protection Act of 1995. Too long, didn't read. There were no intermediary liability safe harbors in it. And for the real nerds among us, there was actually also no protection for vessel hull designs. It did, however, contain anti-circumvention and copyright management information provisions that pretty closely align with the ones that would later appear in Title I of the DMCA, Section 1201 and 1202 of the Copyright Act. So the NII Copyright Protection Act never became law, but of course Congress was also grappling at that time with the problem of digitized property. Fundamentally, the problem is one of cost and burden allocation. The Department of Commerce thought it was obvious that online intermediaries should bear all of the costs and burdens of enforcing copyrights online, but Congress thought otherwise. Congress decided, under some significant counter pressure from phone companies and online service providers, that costs and burdens should be shared. Congress also decided that the interests of internet users should be part of the policy calculus. The Senate Judiciary Committee's report for the DMCA identifies three groups of stakeholders for the legislation. Copyright holders, obviously with a property interest, online service providers with a liability interest, and finally internet users with an access interest. The report emphasizes the importance of creating a workable policy framework for all three groups. So the report thus identifies three overarching policy goals for the legislation. The first, to provide copyright holders with security they needed to disseminate copyrighted works online. The second, to provide online service providers with the security they needed to invest in infrastructure and the development of innovative new services. And then finally, to provide internet users with three things: with lawful access to copyrighted works, with access to innovative online services, and also with protection for non-infringing content that they would upload and share. So Titles I and II of the DMCA are the primary means through which Congress sought to implement these goals. Title I includes anti-circumvention and copyright management information provisions for protecting copyrighted works online, and that could certainly be the subject of its Title II, on which we're focused today, is called the Online Copyright Infringement Liability Limitation Act, or OCILA. It's OCILA that contains the DMCA intermediary safe harbors. So for core elements of the policy arguments embodied in Section 512 are the following. Right holders would bear primary responsibility for identifying online infringements, meaning that OSPs have no duty to monitor their services to check for infringements. Online service providers are responsible for taking down allegedly infringing content, either on notice from copyright holders or when they otherwise become aware of it. OSPs are also responsible for disclosing the identities of alleged infringers in response to court-issued pre-litigation subpoenas. OSPs are responsible for adopting and implementing policies to terminate the accounts of repeat infringers. Okay, users are protected by counter notice and putback provisions. Both users and right holders are protected by prohibition on knowing material misrepresentation, in the notice process that material is either infringing or non-infringing. And then finally, Congress decided that further development of copyright liability doctrines in the online environment would be intentionally left to the courts, which people who do work on Section 512 know are still hashing out 20 years later. And so I'll just close by saying that if you are interested in a really thorough account of the kind of push and pull politics of the DMCA and all of the negotiations that went on before it was enacted, you can look at Jessica Littman's work, Digital Copyright. Professor Littman is a professor at the University of Michigan Law School. There is a chapter called Chapter 9, The Bargaining Table, that really kind of fascinatingly describes the real politics of the DMCA. So thank you for your attention, and I look forward to the rest of the conference today.
Make this work. There you go. All right. Good afternoon. I'll begin with the standard disclaimer. The ideas I express today are my own, and I'm not here on behalf of Charter Communications. I was asked to provide sort of an overview of 512C. The safe harbor for user-generated content. Given the time allotted to me, I'm going to speak at a fairly high level, and I think I won't get into probably the complexities and subtleties that the panelists will talk about later. So I was going to begin with some of the legislative background. I don't want to be repetitive from the previous speaker, but from the perspective of 512C, I think the important thing to realize here is that the DMCA recognized that service providers engage in all sorts of activity that would potentially make them liable for a copyright infringement, and that by limiting such infringement, such liability, the DMCA sought to ensure that the internet, the services offered over the internet, would expand. And if you think about where we are from 1998, that seems like that goal was accomplished pretty well. On the other hand, the DMCA also sought to create cooperation among service providers and copyright owners to combat infringement. I think we can all probably agree they weren't as successful with that goal. And obviously, you can see that with all the litigation that's come out of the DMCA. So these goals, as Anne-Marie mentioned, were accomplished by creating 4 safe harbors, one for digital network communications, one for system caching, one for hosting user-generated content, which is 512C, and then search engines. The safe harbors simply limit liability. They don't speak to whether or not a service provider has actually committed infringement. And I would just note that in my experience, that's something that It's not always clear to business people. You often find, my clients often sort of say, if we don't qualify, we must be liable, and it doesn't obviously work that way. And lastly, I think very importantly, as Anne-Marie said, 512M says that service providers do not need to monitor their service for infringing material. So the safe harbors are structured that to qualify for any of them, you first have to meet 3 threshold criteria. First, you have to be a service provider. And there are different definitions that apply to different safe harbors. But for purposes of 512C, a service provider is a provider of online services, a provider of network access, or an operator of facilities, therefore. This is clearly quite a broad definition. And the courts have uniformly rejected arguments that 512C only applies to electronic storage lockers. The second requirement is that a service provider has adopted and reasonably implemented a policy for terminating repeat infringers. The DMCA geeks in the room know that there's been a lot of controversy over this criterion. And, the recent Cox case had shed some light on what it really means. And I think there's, at this point, there's kind of consensus that a service provider has to have a policy that under certain circumstances results in termination, that when a subscriber actually gets to the point where the policy would suggest that they need to be terminated, the service provider actually has to terminate subscribers, which is something some service providers have tried to avoid doing for the obvious reasons. And then lastly, the Cox case rejected an argument that really began in Nimmer's treatise that the repeat infringer policy only applied to adjudicated infringers. And finally, the third threshold criteria is that you not interfere with standard technical measures used by copyright owners to identify or protect copyrighted works. Whether there actually are any that meet the statutory definition is a separate question. So turning to 512C specifically, 512C exempts a service provider for liability for infringement by reason of the storage at the direction of the user of material on the provider's system if the service provider does not have knowledge that the material is infringing, in the absence of such actual knowledge, is not aware of facts or circumstances from which infringing activity is apparent, and that's come to be known as red flag knowledge, and then upon obtaining such knowledge will act expeditiously to remove or disable access to that content. Secondly, a service provider must not receive a financial benefit directly attributable to the infringing activity in a case where the service provider has the right and ability to control such activity. And finally, there's the notice and takedown provisions, which is what everyone thinks about when you think of 512C, which says upon notice of claimed infringement, if the processes established by the statute are followed, a service provider will remove the content. So in the end, as Anne-Marie said, 512C is structured to make service providers take down content that's infringing when they know of it, but it leaves the obligation to police and detect infringement on the copyright owners. It was that balance that Congress thought would create cooperation between content owners and service providers. And that's that balance which I think has caused such controversy, because from the perspective of many content owners, this effectively allows service providers to ignore widespread infringement on their sites. I think service providers would view it slightly differently, but hence it has not led to cooperation. So turning to just dig a little bit further into each of the 512C requirements, as I said, to qualify for the safe harbor, a service provider must not have actual or red flag knowledge of infringing material, and when they learn of it, they must disable access or remove the material. Critically, the knowledge must be of specific identifiable infringements of particular individual works. Courts have rejected the notion that a service provider has knowledge just because a service provider knows some number of users post infringing material on their site. In fact, courts have even rejected the notion that the knowledge that there's widespread infringement on a site triggers the knowledge requirement. So given that, how do you get actual knowledge or red flag knowledge? For actual knowledge, the easiest way is to get a DMCA compliant notification. And I think it's worth noting here that notifications that fail to comply with the requirements of the DMCA, and I'll talk about that a little bit in a few moments, are not deemed to create knowledge or red flag knowledge. A couple of cases have sort of indicated there may be other ways to get actual knowledge. So there was a case in which the employees of a service provider were hitting the like button on infringing material on their service, and an appellate court said that raised a triable issue of fact as to whether the service provider had knowledge. And in the Viacom YouTube case, the Second Circuit suggested knowledge of executives of infringement might be sufficient, although the trial court ultimately held that knowledge wasn't established. And I think the Viacom case makes pretty clear it's a hard standard to meet. As for red flag knowledge, again, knowledge that infringement occurs on the site isn't sufficient, nor is hosting a site with the name illegal.net, because after all, just because it calls itself illegal.net doesn't mean the content on the website is illegal. There is a case that suggests if a subscriber were to send a letter to the management of a service provider saying, I actually posted infringing material, that raises a triable issue of fact as to whether red flag knowledge has been established. And again, if you have to investigate the facts to find out if there's infringement, those facts are not red flags. I just want to mention quickly willful blindness. The Viacom court in the Second Circuit established that under certain circumstances, willful blindness would be deemed to be knowledge for 512C. Now that is sort of kind of impossible to square with 512M's proclamation that a service provider need not monitor their service. And so there was it's hard to square those two positions. And ultimately, on remand, the Viacom court found that the plaintiffs hadn't established willful blindness. So it remains to be seen what circumstance ever would be enough willful blindness to actually trigger knowledge under 512C. Turning to the financial benefit requirement, as I said, 512C, to qualify for the safe harbor, a service provider must not receive a financial benefit directly attributable to the infringing activity in a case where the service provider has the right and ability to control such activity. The right and ability to control infringement has to be more than the ability to block access to infringing content. That kind of comes from the structure of the DMCA because, as I said earlier, you have to qualify for the safe harbor, you have to, under certain circumstances, be able to disable access to content. So if that's all this meant, then obviously it would be meaningless. Courts have held that a provider must exert substantial influence on its users' infringing activities without acquiring knowledge of specific infringement. One of the rare cases where this was established is a case called Perfect 10 versus Cybernet. And Cybernet provided age verification services for a series of pornographic websites that they had relationships with. And Cybernet essentially monitored the content on these websites because they wouldn't allow you to have certain kinds of content on your sites. And they also had sort of rules about how the content was laid out, how it was presented on these sites of their participating websites. And the court said that was enough to establish the right and ability to control infringement. It's also probably evidence that cases tend to go against porn sites. Financial benefit directly attributable to the infringing activity, that requires a causal relationship between financial benefit and infringement. Setup fees or subscription payments are not sufficient. But a court that addressed this did say the promotion of infringing material to enhance the sale of user accounts is sufficient. So if you're out there marketing to people saying, subscribe to my service, there's lots of infringing movies on it, you probably are going to meet this requirement. Finally, I just want to talk a little bit about the notice and takedown provisions. This is sort of what everyone thinks of when they think of 512C. And it's kind of the core of what 512C is really trying to do. It sets up a very specific way content owners can make service providers knowledgeable of infringement on their sites. And once that's been done, it establishes a formal process for service providers to respond to such awareness. So a content owner has to send a takedown notice, and there are 6 requirements for a takedown notice. It must contain the signature of a person authorized to act on behalf of the copyright owner. It has to identify the work claimed to be infringed. It has to identify the allegedly infringing material. It has to have a contact info for the complaining party, and it has to have a statement that the complaining party has a good faith belief that the material in question is not being used in an authorized manner, and it has to have a statement that the information in the notice is accurate under penalty of perjury. And generally, with some limited exceptions, if a takedown notice doesn't have all 6 elements, it's not deemed valid to trigger the takedown requirements. Upon receipt of a takedown notice, a service provider must expeditiously remove the infringing content. The service provider must take reasonable steps to notify the subscriber that it has removed the content. And that is important because a subscriber can fight the takedown notice by filing a counter notification. In the legislative history, as was alluded to earlier, this was a very important part of the balance that was struck with 512C, because it was viewed as a way to sort of allow individuals to post their personal videos and maybe challenge that something like that was infringing, but also it would put some restraint on content owners from just sending out lots of broad takedown notices. Again, a counter notice has to have 4 specific things in it. It has to contain a subscriber's name. It has to identify the material that has been removed and where it was located. It has to have a statement under penalty of perjury that the subscriber has a good faith belief the material was removed by mistake. And it must contain the subscriber's contact information and consent to jurisdiction of the district court near where the subscriber lives. Now, I represent an I work for an ISP, so I'm not really involved in sites that have lots of content that's put up by users, but I will say my experience is that last consent to U.S. District Court jurisdiction is quite a deterrent to individuals who sort of see that doing this is leading them towards litigation. And following the receipt of a counter notification, the service provider must put the content back within 10 to 14 days unless the copyright holder files an action seeking an injunction. And you can see those takedown and notice provisions really kind of capture the structure of 512C, which places the burden of detection on copyright owners and only makes service providers act once they know about infringement. And that's kind of the end of my Princeton Review level review of 512C. Thank you.